Well, folks, how often does it happen that the Solicitor General of the United States files a brief in the Supreme Court asking for a writ of certiorari on behalf of one of the government agencies, and then the court grants certiorari, and then when it gets down to actual briefing on the merits, the solicitor switches sides and files a brief in favor of the party that used to be their opponent? Well, I don't know how often that happens, but that's exactly what happened in the case of NLRB against Murphy Oil. This is the case in which it happened actually 5 years ago, that the NLRB decided in a case called D.R. Horton that if an employer requires employees to sign an agreement that they will not bring a class action, especially if that's a class action in arbitration, that the employee agrees not to do that. And the NLRB said that's illegal, that's an unfair labor practice, it violates the employee's rights under Section 7 of the National Labor Relations Act. At the same time, we've got the Federal Arbitration Act, which instructs courts that they're supposed to enforce individual agreements to arbitrate disputes. So there's a clash then between the Federal Arbitration Act and the National Labor Relations Act. And we've got the NLRB saying it's illegal, and we've got the Justice Department saying it's legal. And that's NLRB versus Murphy, which is going to be argued at the Supreme Court this fall in 2017, and we're going to expect a decision in 2018. So this will be an interesting case to watch. Thank you for watching this.